Welcome to the Litigation War Room, where you will hear great stories and great insights to raise your litigation game and win more cases. Here's your host, litigation attorney, Maxwell Goss.
Chris Darrow, welcome to the Litigation War Room.
Thanks for having me, Max.
It's great to have you on the podcast. I'm very excited to talk to you today. Chris, you are a patent attorney, a very seasoned patent attorney, but a very interesting aspect of your resume is your work as a special master. And I know that all the litigators in our audience are going to be very interested to hear kind of the insider's perspective on that. I know that you do that in the patent context, so the IP litigators in the crowd will, I know, have a lot to take away from this, but we'll also be talking about things that really anyone who deals with special masters and those in similar roles have experience with. So, Chris, why don't you start, if you could, tell us just a little bit about yourself and about your firm and about your professional background.
Yeah, as you said, I'm a patent attorney, but more broadly, I practice in the area which is called intellectual property. And intellectual property includes not just patent law, but trademark law, copyright, some trade secret law generally also. And more specifically, a patent attorney kind of does three things. He or she will procure patents for clients from the United States Patent and Trademark Office. They also litigate issued patents. And lastly, they kind of negotiate and draft licensing deals for clients. And those are like the main areas that a patent attorney practices. To be a patent attorney, you have to have a engineering or science background. And so I have an engineering background, and after law school, I took the regular attorney bar exam, but you also, to be a patent attorney, have to take another bar exam called the patent bar exam. And so I took that. And so once you pass that, as an attorney, your title becomes a patent attorney. And so that's a little bit about my education. I started my career off working for a large 2,000 attorney law firm. And also I worked for a federal judge as a judicial law clerk. And I learned a lot in both those roles and worked a lot of hours, really worked on my writing and things like that. That's something as an engineer, we usually have to develop a little bit more. So I'm proud of that. As a judicial law clerk, for those of you who don't know, I help the judge with all his cases that he may have or he or she may have. Mostly I assisted with a lot of motion practice. So as you know, federal court now, almost everything is based on written submissions to the court. Motions are filed, reply briefs are filed, and the judge has to decide those motions. And as a judicial law clerk, you'll help the judge with the motions. You also help with trials. You also review all the cases to make sure that jurisdiction is proper in the case. So I had a background initially, working for a judge and kind of understanding how the courthouse works.
Right. So serving as a federal judicial clerk, you both get awesome writing experience, but you also get that inside perspective on how judges think and how they get their job done, really.
That's exactly right. After my judicial clerkship, I went back in private practice for a number of years. And in 2015, I started my own law firm called Darrow. And we currently have 17 patent attorneys. We specialize in patent law and intellectual property law, and more generally. All my attorneys have different types of engineering backgrounds. For example, we have chemical engineer patent attorneys, electrical engineer patent attorneys, computer engineer patent attorneys, chemistry patent attorneys. I have one industrial engineer patent attorney. So, depending on what type of invention I'm working on or what type of technology, we have like sort of the right attorney to kind of match up with that, who has a background in that technology.
Yeah, that's great. Do you focus on particular industries or technologies?
Well, my law firm's here in Detroit, Michigan, so we do a lot of automotive work, obviously. Our largest client is Toyota, and so we're doing a tremendous amount of work for them. But, these large companies now, they're not just like the traditional automotive companies. They're really technology companies. So we're doing everything from computer inventions to mechanical inventions to electrical inventions, you name it, we're kind of doing it. And so we kind of have a wide practice area.
And so you spend much or most of your time when you're not managing your law firm prosecuting patents and getting involved with patents and patent law and the other ways that you describe licensing and so on. But you're also a special master. I'd like to talk a little bit about that. Let's just level set. When I think special master, the TV show Bosch. A few years ago, there was a series of episodes where Honey Chandler, who was his nemesis at the time, had become a special master in a case that he was doing investigations for. And I remember my dad, who also watched the show, asking me, what is a special master? So, Chris, for all the Bosch fans out there and for everybody else who wants to know what a special master is, can you kind of give us the big picture of what a special master is and what they do?
A special master is someone who's appointed by a judge to help the judge in a particular case. And usually the special master has some type of specialized background that would be useful for the case. For me, a lot of times the cases deal with technology. So they could be patent cases, they could be class actions. And as an engineer, I'm able to bring that specialized knowledge to help the judge. In patent cases in particular, there's a whole regulatory framework of surrounding patents and how the history of a patent gets issued. And I have knowledge of that. And so I bring that knowledge to be able to help the judge.
I'm sure you know this better than I do, but my understanding is that in Europe, for example, they have specialized courts and specialized judges who are technically proficient, both on the technology side and experts in patent law who adjudicate patent cases. And as far as I know, our system is unique in that certainly while we have the Patent Trial and Appeal Board, which is populated with those with that kind of technical background, patent cases go before lay judges and lay juries. And so it sounds to me, is it fair to say that bringing on a special master is a way to kind of bridge that gap to help these judges to adjudicate these cases in areas where they really don't have any particular expertise?
That's exactly right. And so, as a patent attorney now, and also having previously been a judicial law clerk, I'm able to kind of help the judge bridge that gap, right? So, and really when I think of my job as a special master, I think of myself as how can I speed up the learning process for this judge? Judges are extremely busy. They have many cases, hundreds of cases on their docket. And, they have a limited amount of time. So I'm always about how can I speed up the learning for the judge, bring him up to speed or her up to speed in a quick and efficient way. And I think they appreciate that. And that's, to be honest, I think that's how I keep getting appointed to cases.
Yeah. So obviously patent cases, but what other areas are special masters used in?
They're used in a lot of cases. Sometimes they're cases that maybe there's a financial accounting that needs to be determined. But a lot of times I'm appointed in cases where a discovery master is needed. Maybe the parties are just butting heads quite frequently and motions are being filed. And the judge just wants someone to kind of work with the parties more closely, kind of walk them through the litigation process. And that's a role I've performed also many times.
And whose decision is it to appoint a special master? Does it usually come from the judge, or do the parties ever and their counsel ever propose that?
It can be proposed by counsel. Most frequently, it is by the judge. The judge typically, in my cases, will tell the parties up front, like, hey, I've worked with the special master previously in many cases. He does a really good job. I'd like to appoint him in your case. You can go on his website and look at his background. You can call him if you want to learn more about him or something of that nature. But, check him out. Let me know in a week if you have any objections to appointing him. And, if they have any objections, they'll let the judge know either formally by filing a document or just informally. And ultimately, it's the judge's determination of whether to appoint a special master or not.
And who pays for it?
The parties generally pay for it. And most typically, it's 50% to the plaintiffs and 50% to the defendants. That's the typical arrangement. And, in my cases, I'm blessed because I have a law firm with a lot of attorneys I work with, and I'm able to charge basically a discounted rate to work as a special master. And my goal ultimately is, I got my career started here working as a judicial law clerk in the Eastern District of Michigan. And I just really want the Eastern District of Michigan to be known as a competent jurisdiction where high technology cases can be decided, efficiently and competently. And ultimately, that's my goal. It's my way of kind of giving back to who kind of started my career for me.
Yeah, that's great. Well, let's talk a little bit about your special master practice. I was looking at your website bio and counting up the number of cases listed there where you've served as a special master or in a similar role. By my count, it was 75 plus. That's amazing.
Yeah, that's definitely accurate. It's been quite a few now. Let me tell you the story about how I initially started working in this area. I think it's kind of interesting. After I was a judicial law clerk, I was a practicing patent attorney, probably at least 10 years out of school. One of the federal judges approached me and said, "Chris, I'm interested in developing a model set of rules to manage patent cases for my courtroom. Would you be interested in helping me develop these rules and procedures?" And I said, "Absolutely, I would sit down with you, Judge," because I knew the judge from my earlier days as a young lawyer working in the courthouse. And so he commissioned sort of an informal committee to help him develop his specific procedures for patent cases. And it included a couple other federal judges, and it also included several patent law practitioners that were frequently litigating cases in federal court here in the Eastern District of Michigan. And the product of that work was a model order to manage patent cases, basically a model scheduling order that had a lot of the things that you may see in local patent rules built into it so that, parties could kind of efficiently manage the patent case from the beginning of the case to the end of the case. And it would have things like a claim construction process and infringement and invalidity contentions and those types of things. And the judge put it on his website and he used that. Ultimately, it kind of started becoming popular. Other judges, when they started getting patent cases, they had heard about this order and they started using it. And so at a conference, the judges asked me to speak about manage a patent case from the judicial perspective. And so I presented to the court and to all the judges my thoughts on, the model order and how to manage a patent case. And some of them found it very helpful. And one of the judges asked me if I would sit down with him. He had a patent case and he was interested in, seeing if I could help him. And through that, I got my first special master sort of role. And we did that case. And ever since that case, I've been off and running. I think I did a good job, helping him with all those motions that are filed with claim construction, with disputes regarding infringement contentions and invalidity contentions, how lawyers have disputes. And also, I would look for an opportune time in some of these cases to approach the parties and say, "Hey, have you ever thought about settling this case?" And, no one wants to show weakness in litigation. They don't want to be perceived as being weak and asking about settlement. So I would raise the issue when I thought the time was right. Maybe some of the issues that were fleshed out through motions or through claim construction or whatnot. And I had a good record of settling a lot of cases. And a lot of times it was just raised by me and it would save the parties time. It would save the court time and everybody kind of was happy.
Yeah. So you'd not only raise it, but you would essentially mediate the case.
Yeah, I would. I would say you could mediate it with me or, you could go out and hire a third party mediator. But I'm happy to do it. And, since I was raising the issue, a lot of times I would kind of just go back and forth a little bit myself. And through that, we would start talking. And then it made sense for me to kind of do that for them, to mediate the case. And so, yeah, we had a really good success rate. A lot of cases are settled. As you know, most federal litigation settled anyway. So it was just an opportune time for me to ask the parties if they wanted to talk. And everybody's always usually willing to talk if it's raised by someone in a judicial role. So, and as a special master, I'm in a quasi judicial role. So I could raise that issue with the parties and we'd be off and running, talking settlement at some point.
Wow, that's really interesting. So there are a lot of facets to your role. You're sort of a law clerk and technical expert and mediator all rolled into one.
Yeah, that's right. And, especially in the patent cases, there's a lot of basic principles of patent law that if you're a generalist and you haven't been exposed to patent law, you just want to know. And, I have the opportunity to basically bring the judge up to speed on these issues and speed up the learning of the judge. And so they're very appreciative of that. Being a special master is not just about patent cases. You can be a special master in many types of cases. So in addition to patent law cases, I'm a special master in class action cases. Usually in that role, it's a discovery master, and more broadly, I'm just assisting almost as a judicial law clerk. I can help the judge do research. I can help the judge tee up the issues with the parties. I can also discuss settlement, resolve discovery disputes. There's a lot of ways that I can bring value to the parties. And since my billing rate is so low, it's just a helpful tool for the parties to have. That doesn't prevent them from going to the magistrate judge or going to the federal district court judge if they need something. But if they need something quickly, and I can be an avenue to get those issues resolved for them, either formally through the judge or informally by doing kind of meet and confers with the parties directly to help them resolve the dispute, whatever dispute they're having in the course of the litigation.
Now, Chris, I'd love to hear about some of the cases you've worked on. Now, in your role, I know you're not allowed to, or would not be prudent for you to take sides, and there may be limitations on what you can share, but I'd love to hear whatever you can share about any specific cases you have handled.
Yeah, sure. I think one of the most interesting cases I had was one of the patent cases I had that's easy for everybody to understand was there was a product called the Rainbow Loom. And what it really was there was a local engineer who had two daughters and he did not have money for their college. He only had like maybe, I forget what it was, maybe like $10,000 for their college save. And he said, hey, you know what? I need to go out and develop something and sell it in the marketplace to kind of help fund my daughter's college education. And so he came up with a toy that he developed. It was called the Rainbow Loom. And what you did is you took little rubber bands and you weaved them together using a loom-like device. And you made bracelets and necklaces and things like that out of these colorful rubber bands. And he started initially selling them at independent toy stores. And he would sell them, it was hard to kind of break into the toy store market. And he would sell at one store at first, and then he would get another store. And it really started taking off at some point. He was in a whole bunch of independent toy stores. And then he went to a trade show, and his toy became like the toy of the year at one of these big trade shows. I really kind of caught on. And then once it became popular, there were some infringements that took place. So other people started selling these looms that people could use to make bracelets and necklaces and things like that. And so he ultimately had to sue them in federal court. And I was appointed as a special master in one of those cases. And so I got to help the judge with the case, explain the technology and things like that. And ultimately the case was resolved. And, it was just a really good experience for everybody. But it just reminds you, even in these patent cases, there's people behind the scenes. And it's not just a company all the time, that there are real people there and really makes a difference in their lives. And in that case, we got the case resolved. And I think everybody was happy at the end of the day.
Yeah. And your role in that was to consult on the technical aspects of the invention?
Yeah, that's right. And just help the judge in the case in any way I could, whether it's like we talked about claim construction or, helping in motion practice or helping settle the case. Sometimes we don't take a case all the way to trial and a verdict. We try to get the case settled. And so using my role, we're able to get the case resolved.
Pausing here for a moment for the benefit of our listeners who are not familiar with patent law, what's claim construction?
When you get a patent issued, there's a section of the patent called the claims. And the claims define the kind of like the scope of the invention in words. And a lot of times the words are ambiguous or vague in a certain way. And people argue, well, what is the meaning of this word or this phrase? And it's the judge's job to instruct the jury on what the meaning of that word or phrase is. And so the parties want the judge to give the jury whatever interpretation they're proposing. So the attorneys are filing basically briefs with the court explaining why the interpretation they are proposing is correct and the best interpretation. And and the other side will submit their briefs to the court, explain why their interpretation is best. Ultimately, the court has to make a decision on that. And the way the law says is, hey, when you're interpreting these words, you have to look through the history of the patent application that was filed and its history before the United States Patent and Trademark Office. And also look at the four corners of the patent that was issued and try to come up with the best interpretation for that word or phrase. And so we call that claim construction. What do the words mean? And that's where I kind of bring some value to the court, because I'm able to say, like, okay, this is what party A is arguing, and this is what party B is arguing. You can see the differences, and this is the evidence that both sides are pointing to. And this is the law, judge. And I really go out of my way to make sure it's the judge's decision. I want the judge to make the decision. It's not my decision. And I explain what each side is arguing. The judge has read the briefs himself. He discusses it with me. I'm like a sounding board for the judge. And ultimately, he'll issue his or her opinion on, what he thinks the interpretation should be.
Well, and claim construction is a major, major stage in any patent case, because depending on the outcome, it may affect the claims that a plaintiff is able to assert, or whether the theories of validity or invalidity hold up.
Yeah, that is exactly right. Every patent case is centered around that claim construction. So claim construction generally comes before dispositive motions. So you interpret the claim to see what it is. What does the phrase mean? A lot of times, if one party wins the claim construction, it's case dispositive, like, whether they're going to win or lose the case. So sometimes, if the claim construction goes one party's way, the case goes away. I mean, it has to settle or get dismissed or whatnot. And so, yeah, it is a major part of the case.
Thanks for indulging that nerdy digression, Chris. But bringing things back around to cases you've handled, you told us about the Rainbow Loom case, kind of the human dimension that you could see in that case. Are there any other cases that our listeners might be interested in hearing about?
Yeah, there's another interesting case I had. I remember it and called it the indoor snowball fight, and it really dealt with copyright law. So at the Christmas holiday time, a company had started selling a red bucket filled with basically stuffed snowballs. They were fake snowballs. They were made out of cloth, and stuffing was inside this spherical looking snowball that was painted white or colored white. And on the outside, it had a snowman's face on it, including a carrot nose and a mouth and eyes made of coal and things like that. And the idea was you would buy this for someone at the Christmas holiday, give it to them as a gift, and then they could throw these stuffed snowball looking things around the house at each other. So it was called the indoor snowball fight. And another company started selling something similar. They had a red bucket and they had a snowman, stuffed snowballs inside of it. And the issue was, were the buckets too closely similar in coloring and design? And were the snowballs too closely similar in the way that the snowmen were drawn and things like that? So that was a copyright case. And again, that was another case I had to help out with. And it was very interesting because it raised a lot of copyright issues. Like, how closely can someone sell the idea of a bucket filled with these fake snowballs that you could throw around the house at each other? And so, you get into like fair use and what is original copyright material. And so that was a very interesting copyright case. Another interesting case I was appointed as the discovery master in this case, but in this case, an inmate in a jail had died after an altercation with the jail guards. And the family of the inmate that passed away had sued the local jail. And I was appointed because there were a lot of discovery disputes and things like that. And maybe just not of a meeting of the minds as far as, how to manage the case from a judicial perspective. So the judge asked me to come in and kind of, help the parties usher them through the litigation process as a discovery master. And that was another interesting case. It wasn't a patent case. It wasn't an intellectual property case of any type, but rather, a wrongful death case. And so it was another interesting case that we were ultimately able to get resolved. But it just goes to show you that special master work comes in all different shapes and sizes and types of cases. And so most commonly I'm working in the patent field, but there's other types of cases that I help out on also.
Yeah, so interesting. It's got to be really fascinating getting that insider's perspective on so many different kinds of cases. Well, to kind of wrap up, a question for you that I have is what's one thing that you would say to litigants, to counsel for plaintiffs or defendants who are in a case where a special master has been appointed?
Yeah, I think it's an opportunity for them. I would say this is an opportunity for you to save money and more efficiently get your case to trial, because a special master brings specialized knowledge, and whatever it is, whatever type of case it is, he can or she can help you get to trial easier, more efficiently, or hopefully cheaper, because you're not going to be butting heads on issues and things like that as much as you may without someone to reach out to and get issues quickly resolved.
Do you find does it speed up the time to trial?
I believe it does tremendously. So
Mm.
in the patent case example I gave you, we came up with the judge and I came up with a procedure, a scheduling order for patent cases. And the scheduling order provides to get to trial anywhere from 18 to 24 months. And so in a patent case, that is pretty good. If you could get to trial 18 months, that's as fast as like going to East Texas or some of these other venues that we're always advertising, getting to trial very quickly.
The rocket dockets?
The rocket dockets, exactly right. And so, our goal wasn't necessarily to be the fastest. We just wanted to be competent and make sure that, cases moved along efficiently. And so what we said was there's no set number of months that a patent case has to be decided by. But what we would do is give parties a guideline. Like, hey, in the typical patent case, we get to trial 18 to 24 months. Use that as a guide in proposing a schedule to the court. Now, some patent cases might be bigger than others. Maybe they deal with pharmaceutical inventions that take more time, or maybe they have more patents involved and everything's going to take more time when you have more patents. Maybe there's a number of defenses involved or witnesses or whatever. So one size doesn't fit all. And so we would count on the parties to work with the special master and say, hey, let's come up with a reasonable schedule for your particular case. And the typical schedule the court sets is 18 to 24 months. But if you have other circumstances that warrant a longer case, we'll keep an open mind that we can go longer if we need to. But that kind of sets the parties up to negotiate something that's reasonable and keeps the case on track. Because we've seen cases in the patent area where they're going on, 5, 6, even I've seen cases go on for 7 years, so when I'm a special master, we never have that situation. It's always getting the case decided right around a couple of years.
Chris, this has been so interesting and so instructive. Very helpful things that we can keep in mind next time we are in a case with a special master or have the opportunity to involve a special master in our case. And it was great hearing about your patent practice as well. If listeners want to find you or if they want to contact you, how do they get in touch?
Sure. Our website is darrowmustafa.com. That's the easiest way. And on the website, you can find my email address under my bio, and they can ask me any questions they want. I'm easy to get to. I'm also on LinkedIn. So if anybody's just wants to connect on LinkedIn, I'm always happy to do that.
And Chris, I have to ask one more question. Your name is Darrow. That's a very lawyerly name. Do you have Clarences in your family? And did you know from birth that you were going to be a lawyer?
Well, supposedly I am related to Clarence Darrow. Now, he was born in, the 1800s. And, So you have to go back the family tree a little bit, but yeah, we are related, and my understanding is we shared the same grandfather. That's where the tree meets, essentially. So
Oh,
it is
interesting.
a good, yeah, it is a good name.
Yeah, for sure. Well, okay. Chris, it's been great. Thanks so much for sharing your insights on the litigation war room.
Thanks so much, Max.
You have been listening to the Litigation War Room with litigation attorney Maxwell Goss. Maxwell Goss brings forceful advocacy and creative solutions to trade secret, IP, and business cases in Michigan and around the country. For show notes and more episodes, please visit us at thelitigationwarroom.com. If you enjoy the show, please be sure to subscribe, rate, and review wherever you get your podcasts. Thank you for listening. The Litigation War Room, including the podcast and all website content and social media, is for informational and entertainment purposes only. This podcast does not provide legal advice and does not give rise to an attorney-client relationship. All views and opinions expressed on this podcast belong to the guests expressing them and do not reflect the views and opinions of the Litigation War Room.